Welcome, everyone, to the Main Street Business Podcast with Matt Sorensen and Mark Kohler. We're delighted to be with you on the final episode. This is the final episode. You've waited to see how this thing's going to end. And
Yes.
we're here of the estate planning series.
I love it. And we got to applaud those that have trudged through this. Yeah. Now,
They're loving it.
Yeah, no, this is good stuff. I mean, I've already had a number of comments via email and social media. People grateful for the info and keeping it simple and to the point. And these will be also placed on our website under our estate planning page. So you may be watching it here a couple years after we did the podcast. We've tried to make these evergreen so that they really are a one-stop shop to understand the beginning, middle, and end of a trust. So
yeah, just like your favorite Netflix series, you want to go back a couple years and watch it again, because it was so great. That's what we're trying to replicate here.
Yeah, Breaking Bad is timeless. It just really is. So
right. Yeah.
Now, today's topic is funding and maintaining your trust. So once you set up your trust, what do you have to really do? I literally had this phone call on a call this morning. We were working on a charitable trust with a client, and they asked about the revocable trust. They're like, well, how much does it cost to maintain? So I'm just going to get that out the gate first and foremost. I said, nothing. There's no cost. There's no state fee, federal fee, IRS fee, no tax return, no fee to us. The only cost may be doing an amendment once in a while. Once a kid pisses you off and you want to cut them out, you got to do an amendment, maybe $200, $300, $400. So
yeah, and I think the nice thing about the trust, okay, you signed it. That's what we're talking about here. You signed this thing. It's done. It doesn't get filed. It doesn't get recorded. It's an internal document you're just going to keep. All right. It's going to be in your safe or in a special place in your home. Make sure people know where it is, right? Your loved ones, whoever's the trustee, that upon your passing, or your spouses, if you have one, they know where it's at. We save an electronic copy at our office, but you're signed. And now there are some steps you do need to do, though. We got to fund.
Yes.
And fund.
I'm trying to find the analogy.
You put the fun in funding, though, here. So,
Yeah. I'm trying to figure out, like, if it's a good analogy. Like, this is a new, washing machine. If you buy it, you plug it in and it's all ready to go, but you don't put anything in it, it's not going to get, it's not worth it. It's like and the trust to really do its job and keep your clothes clean or whatever, you got to fund it. You got to put assets in the trust. So we call that funding the trust. I guess if you wanted to talk about maintaining your trust, it's whenever you buy something, let your trust buy it rather than you. Now, sometimes there could be lending and banking issues, and this point that I'm making, we'll flush this out as we talk about transfers. But the point is, maintaining your trust is about keeping it funded. It's not just funding it once. You're going to buy something 6 months from now. You might set up a new LLC 6 months from now. So that maintaining it also means keeping it funded.
Yeah. The only thing I'll say on maintaining before we get into funding, which is really the big topic, but the only thing I'd say on maintaining is if you have a significant life event or change in your life or your family, or those that could be trustee or heirs, beneficiaries, you want to, that's a maintenance thing. You got to change some stuff up. You have a divorce, you have a kid, that's changed their life situation that could affect whether you want to give them something or not. A trustee, relationship doesn't go great. I don't know. Something changes.
Yeah.
So
change happens.
Yeah.
So got to be on it. Think of the trust as a pseudonym. It's the alter ego of you, and that's okay. We want that trust to really own everything. Now we're going to talk about bank accounts and checking here a little later too. So, but let's start with the big two or three. Matt, you wanted to start with real estate, I think, right?
Yeah, let's start with real estate because most people at least have a home, and that's the first asset we want to make sure goes to the trust. And your home is a little unique. For those of you that are real estate investors, got other real estate, that you may have LLCs. We're going to talk about those separately. But just your home, your personal residence, that's going to be owned directly in the trust. You're going to have a deed going from you, your name, over to your trust's name. That's going to be asset number one you should be thinking about. Now, when you're working with our office, we do 50% off on our deed transfers. So there's some discounted there if you're doing it within, I think, 90 days of when you get your trust done. So, but make sure you do this funding part. So many people do a trust or they do it online and they kind of do it themselves and they don't finish it and fund it here. So step one, real estate deed.
Yeah, and let's unpack this a little bit. So when you're going to deed your home to your trust, someone on my live broadcast yesterday on YouTube asked, how do I transfer my home into my trust? Well, it's typically going to be a warranty deed. We don't like the quit claim deed because we want to warranty any rights you might have individually from your title policy or anything you may have had from the purchase originally. So use a warranty deed. In California, it would be called a grant deed. And keep in mind, there's 3,500 counties around the country. So every county may have a different cover sheet or a little form or a filing fee. This is where we handle probably 85, 90% of those counties around the country with our deed staff. In some states, it's so cumbersome, it's better to just go to a title company in that state, Hawaii, Pennsylvania, a few of those. If you call our office, we'll give you the bad news. But you've got to use the right form, the right cover sheet. You're not going to ruin your loan with the bank. There's not going to be a due on sale clause. No one's going to care. Just get this thing deeded. And if you're afraid of your homestead exemption or the tenancy by the entirety, which are asset protection strategies I talk about in my book, those are going to be protected as well by putting it into your trust. You want to make sure you use the right verbiage, but you're not going to ruin those if you do it right.
Yeah. Okay. Love it. All right. Now let's talk about other real estate, not rentals. Let's talk about maybe you've got a second home, you own some land, any real estate that you typically have in your personal name, and you think of our trifecta. We've got our properties in LLCs that are rentals typically on your right side, but you might have some not a residence. Maybe it's a second home, a cabin, some raw land. It's not in an LLC, but those are the assets, again, we're going to want to deed into the trust. Now, real property in your name when you pass away must go to probate if it's not in the trust. So that's why we're starting on real estate and we're like, hey, your real estate that you own personally, get that into the trust, because when you die, your family's going to have to go to court, even if you have a will, even if you have a trust and you didn't deed the property into it, they're still going to have to go to court and say, hey, we're supposed to get this. And the judge has to sign it. You're going to have fees. You're going to have to give notice to other people. It's a pain in the butt. So get it in the trust. That's what we're trying to avoid.
And if you have real estate that should be in an LLC or isn't an LLC, we're going to come to that in a minute. We'll come to that in a minute. But this is just, maybe you've got a acre of plot down the street from your own house, or this little piece of land up in the mountains or something, and you want to have it not in your own name. Like Matt said, any asset, any property in any state will have to be probated in that state. So you want to think nationwide, what real estate do I have that's not in an LLC already? Let's transfer it to the trust. And I need to point out this privacy thing. We are really trying to figure out a loophole or a strategy of trying to keep your name off as trustee on public record at these counties when you record your trust. We don't want your name in the trust because there are other places where privacy could play out. We don't want your name in the trust, but you are the trustee, and counties across the country require the name of the trustee upon the recording of a trust. And a company, only a trust company validly chartered by the state can be the trustee. It's got to be a person. And just putting a random person, even one of us lawyers, as your trustee for this recording can be very problematic. So you're going to generally be the name of your trust as trustee. Your name will be there as trustee, even though your trust name might be different. So keep that in mind. We can use LLCs to hide your personal residence or other real estate, but it's not going to happen right now through the trust itself. we would probably set up a holding company, which we can do. We can create more privacy, more pieces, parts, and cost at times.
Yeah.
But
Yeah.
all right.
Okay. All right.
LLCs?
Let's get to LLCs, which
Yeah.
many of times are going to own real estate. Now here, or maybe like Mark said, you've got some rentals that you got to get to the LLC. Let's just get them in the LLC. For those of you that already have LLCs, we're not changing the deed now. The LLC owns the real estate. What we're changing now is ownership of the LLC, which is a membership transfer. Much easier because nothing's recorded. It's an internal one-page document. You generally want to update and amend and restate your operating agreement too. There's an additional fee if you want to do that, but we're just going to have a membership transfer that says, hey, Matt Sorensen doesn't own it. Matt Sorensen Trust owns it now. And it goes right over to my trust. Now my trust owns the LLC. LLC owns the rental. When I pass away, trustee just goes and takes over. LLC owns it. They can sell it from the LLC. They can take over control of the LLC as the owner. They could appoint themselves manager, because now the trust owns it and they have full authority to do that. They can just run and take off and control everything, of course, as you've outlined in your trust.
Now, this is going to be through what's called a membership transfer agreement and minutes allowing for that transfer. Now, if you own the LLC already 100% you, easy schmeezy, our service could be under a couple $100 to get the whole thing transferred or less. I can't remember, but it's in there. Very affordable. Now, let's talk some nuances. I've had clients to say, well, I own a syndication, or I own 2% of this LLC here, or 32% of an LLC with my brother-in-law, or whatever. Well, to transfer your share of that LLC to your trust, 99.9% of operating agreements are going to allow it. It's just getting the powers that be to do it.
Yeah.
So you have to you got to reach out to the manager of that LLC and go, hey, I just set up a revocable living trust. I would really like to transfer my membership interest to my trust. Can we initiate a membership transfer agreement? They're going to sometimes say, well, there'll be a cost because we got to pay a lawyer to do it or this or that, and say, well, I'll pay the cost, or I'll have my lawyer prep it. Can we just get it done simply? But the minutes to approve the transfer are going to have to be signed by some people in that LLC because they want to know who you transfer to. So there could be a little bit of paperwork, it could be a little cumbersome. But you have to remind these people, this is in their best interest too. They don't want you to die in your name. They would love it to be in your trust because that makes their life easier when you die. So remind them that. This is not a pain, a bad thing. It just takes some steps.
Yeah, most of those private funds are companies that have a brain and have some lawyer or someone that thought this through, or like, yes, please let me help you with that, and they got a procedure for it. So, if it's you and your brother-in-law and your, college friend or whatever, I don't know, you get through together this thing, and you didn't have lawyers involved in particular, it might be a little messy, but just get it done. It's still not hard. This could still be a one-page assignment of the thing. You just might have to get approvals when there's other people involved in this company and you're not in control. So,
yeah. Well, we're at that important point in our show to give some time to our sponsor. That would be Rockstar. And so I need to make sure all of you know that you can be a Rockstar tax and legal aficionado yourself by being the captain of your own ship. So we want to applaud you for being here. So Corey, could you grab me a cold Rockstar from the fridge? I would really appreciate it. Right down the hall. I wish Rockstar had sent us that.
I love it.
Case of
Mark's
Rockstar.
Thirsty, so he does a plug for Rockstar to basically ask for a drink.
I had to,
I see what you're doing.
You saw the ploy. Yeah, that was all part of a master plan. And I wish Rockstar had sent me that can of drink, that wonderful goodness, for free for the plug that I just gave them, but they did not. So that day will come. But thank you, Corey. And say what? Okay, yeah. So just make sure this is proper sponsorship. There we go.
That sounded good.
How's that feel?
That
no
nice.
Carbonation, no sugar, electrolytes, B vitamins, and 160 grams of pure caffeine goodness.
Wow.
Okay,
All
All right,
right.
I'm ready to move on. Are you?
Okay. Yeah.
Okay.
All
All
right.
right.
Now, let's talk about your other companies too. If we were thinking
Yes.
of trifecta, we kind of hit your LLCs, owning rental real estate, or maybe your investment stuff in a partnership or syndication thing or PPM, whatever. Now let's go to
Yep.
the left side too. You might have your S corporation.
Yes.
Okay. We want to do a stock transfer on that. Similar process here. And as long as it's going to your revocable trust, it's fine. S corporations have to be owned by individuals, but our type of S trust qualifies under these types of structures. So you can have your S corporation stock transferred to your trust.
Yeah. And let's hit a couple nuances here. Let's talk about those people that have an S corporation that is registered with DOPL, which stands for the Department of Professional Licensing. It may vary in some states, but that's the
You're
gist.
like
So
you're like a doctor or a lawyer or a real estate agent or
real estate agent, very common, CPA, engineer, architect, a licensed family marriage therapist, an LFMT, the LMFT license. Yeah, LMFT, I nailed it. But their office can be some of the most difficult to work with because they don't want your trust in there. The Department of Professional Licensing. They want to know you, the licensee that took the chiropractor exam. You're the one that owns this LLC. They don't want to, or S corporation. They don't want to see a trust in the mix. So our strategy here is when you're a licensed professional, set up your S corp with the freaking name and the way Department of Licensing wants. Send them the paperwork, kiss them goodbye, flip them off, walk out, whatever you want to do. Then we're going to do this transfer internally in your book. Because if something happens to you and you die, you want your trustee to come in and collect accounts receivable, do finish the Medicare billing for the month, go and pay, get this done, that done, work with the
get the bank
partners.
account that has some cash in it, like
Yeah.
all the assets and equipment and the the lease and all these things that need to be taken care of. And this is something that is kind of like, well, why hasn't the law figured this out? Because no one cares. DOPL doesn't care. Just transfer it to your trust. The Department of Professional Licensing or any of these licensing bodies, they're not going to stamp it because it doesn't fit the law for them. But the estate planning laws, and every estate planning lawyer, anyone who has a licensed corporation knows their trust needs to own it. Their trustee is going to come take over and will have the ability to do that. So I wouldn't stress too much about it, but just get the stock transfer done. Remember, this is an internal document anyways, the ownership here.
Yeah.
So just get the transfer done. Keep that stock transfer handy.
And this is a good point to talk about maintenance again. So now, with all that said regarding real estate, LLCs, and corps, now moving forward, okay, you do this, you get all your entities done, you get your real estate, and lo and behold, 2 months from now, you need a new LLC. You bought another piece of rental property or bought some cryptocurrency that you want to protect in an LLC. Okay, when the law firm asks you for the information to set up your LLC, we're typically going to ask, do you have a trust? Now, wherever you're going, if they don't ask that, you need to volunteer it and go, I'm not going to be the owner. My trust is. Now you've saved a step because you don't have to transfer it later. You're just going to set up these new entities right from the get-go with the trust. And when you go to buy property, you might have to close in your name because of Fannie Mae and Freddie Mac lender crap. But then as soon as you close, you deed it over to your trust. Don't tell them you're going to do it. Just do it. Don't, anybody that wants to get, 10 bankers involved, just ask them can I go to the bathroom while I'm in the bank? It's going to require an executive order from the vice president of the region. So just don't go in and tell the bank what the hell's going on. Just transfer after. It's not a problem.
Yeah. Okay.
For you guys that were teenagers, this should be easy. You would never ask to stay out late. You would just stay out late. It's a much easier solution.
Don't ask for permission. Ask for forgiveness. Okay. Love it. All right. Let's talk about another. I mean, you did mention cryptocurrency, though. I want to kind of give a couple tips on that.
Ooh. Yeah. You know what?
Give a couple tips on your crypto.
We've got to talk about how do you bequeath crypto. And this could be precious metals. It could be, and we should talk about timeshares. Why don't you hit crypto and then I'll mention timeshares too.
Okay. Does anyone want to inherit a timeshare?
Yeah. As long as I didn't pay
Is
for it,
this
I'll
an
inherit
asset or a liability? I don't know.
it. I just don't want to pay for one.
Let's talk about something some of your family may actually want to
Yeah.
get, your crypto. Okay, now we want to make sure they get this. And this is what's important with crypto. It's hopefully over the years, this is going to improve because this is a tricky one. If you think about your bank account or cash just sitting there, we're going to talk about that in a second. They're going to show up with a death certificate. You have a beneficiary designation that who gets your account when you die. If it has your trust, easy peasy, done. They show up with a death certificate, goes over to the trust who is listed on the account with a beneficiary designation. With your crypto, and this is even something Coinbase and Gemini and a lot of custodial places, Kraken, they're still trying to figure it out. Now, right now, most of those places have a process. If you have crypto custodially held with one of those types of companies, where you present a death certificate of the deceased person, and the heir in the estate is able to get it. If there's a surviving spouse, that's easier. If it's kids or others, it becomes a little more complicated. You're going to end up in probate court typically. So, but what about everyone else? What about all the DeFi crypto? My crypto I don't have with the custodial partner. There's no other company that has it. It's on my Trezor device. It's on an Nano Ledger. It's on a MetaMask wallet or a Phantom wallet. I mean, how is my family supposed to get access to that? And I've got multi-factor authentication. So even if I leave them my user and password, how are they going to get into this? All right, this is tricky. So a couple of tips. One, your private keys. One option, and I'm not saying this is all settled and done. There's one way to do it. One option would be is put those private keys in a super safe place, like a safety deposit box at a bank. I hate to say it. I know you don't love a bank. A lot of you that have gone DeFi, but keep your private keys there and give instructions to your trustee that could be in your plan on how they go access that. And they could be on your accounts over there at the bank so they could get access to them upon your passing. But that's one option. And you could do the same thing with users and passwords. And there's other places, of course, you could put this, but it's got to be safe and secure.
Yeah. And here, opens the door to an important point. When you do an estate plan, it's more than just a trust. We're going to give you a binder, and this binder is going to have funeral and burial instructions, powers of attorney. We've talked about this in the prior two videos. The point is, use this binder as a launching pad to get a fireproof safe in the house. Even safe deposit boxes are not cheap. I'm going to rely on a fireproof safe. That's just my take. I'm a little cheaper that way. And make sure that trusted person in your life, it might be your spouse, it could be a best friend, a parent, a child, your attorney, whoever it is, make sure that one person knows the combination of that safe. And then on a regular basis, make sure in your safe are these passwords and these cryptic type things, that you could be passwords. There's so much more I want to say. I'll come back to it. But the point is here, the binder itself should be in that fireproof safe with this type of stuff. And if you're the type of person that changes your password every week, well, that requires you updating that piece of paper in your safe every week. Because if you die in the meantime, that money's gone forever. So
yeah,
you got it. It comes with the more security minded you want to be. It's going to take a little extra work.
Yep.
The funny case to me, Matt, it was in Newsweek about 4 or 5 years ago. Those that have been to a live workshop of mine have heard me talk about it. A lot of people. Okay, we're going to go back in time, back to the good old 80s. Some of you watching Stranger Things, flashbacks. I'm waiting for episode 8 and 9. It's killing me. July 1st, Matt, if you're wondering.
I got to catch up. Peaky Blinders is coming out, so I was all excited for. I did love Stranger Things, though.
Yeah. So in the 80s, there was these things called LPs or records. Now, they were called vinyl for short because they were made of vinyl and they were flat like a pancake, people. And you'd put them on a turntable. I know this is crazy. Some of you that never seen these before. And then you'd play music. Now, when you bought a record, you didn't own the song. I didn't own Kiss, Shout at the Devil. I didn't own the song. I just owned the album. And if I broke or scratched my album, it was ruined. But I owned that record. Well, come to find out, what about our digital music? What do I own? Do I own that song that just came out by Britney Spears? Nope, I do not. I just have the rights to listen to it on that platform. Well, about 4 or 5 years ago, Bruce Willis was at a party, and he's big into music, and he was, and he's got a huge Apple iTunes, whatever library. And he discovered that in these contracts for Netflix and Prime and Apple Music and when you die, your account's gone. All that music you purchased, it's not yours. You just have the right to listen to it, and it's a lifetime agreement. When you die, that's gone in most of these things. So Newsweek did this big old 3-page spread of all these digital rights that people have to access movies or music and this and that. And when you're gone, what the probate or the estate issues were. It was really fascinating. So Bruce Willis said, I'm going to sue Apple Music. And he didn't, and it got some news, but if you watch TMZ. But anyway, it was really fascinating. And so here's another point in this password list is make sure someone has the passwords to your Netflix and Amazon and this and that. Because if you don't leave it to someone, they ain't getting back in. It's over.
Yeah.
So interesting, huh?
Okay.
Isn't that interesting? Yeah,
I didn't know that.
Corey's pissed over here.
You're bringing Bruce Willis in, what was his name in Die Hard? Lieutenant Detective.
In Die Hard?
Yeah, Die Hard Detective.
Oh, John McClane?
John McClane. That's John McClane.
Gosh, of course. I was like, what are you talking about?
Yeah. Yeah, that's right. Gosh.
Yeah.
All right. Okay. Let's get back to, actually, let's hit another category. Are you ready to switch categories?
Okay. I'm going to say.
You want to say anything else on crypto?
Why don't you mention timeshares? And here's the thing. I think timeshares is a good topic for catch-all. You want to just think of anything you might own, like a timeshare. Do you want to comment? I've been talking here. I just don't want to. I mean, you got to.
You left me timeshares. Thank you. Let me tell a Bruce Willis story. All right, you're up.
Okay.
Timeshares. Oh, let me give. Okay, timeshare. Now, timeshare is a deeded piece of property, actually, in a lot of the instances. There's actually literally it's a deed, and so you have to get it transferred to your trust. Now, it's a pain in the butt having to get that done because there's a management company that has to sign off on it. Now, a lot of them are familiar with this, and particularly the bigger ones, but there's going to be a cost and you're going to have fees and you got to contact the management company and jump through their stupid hoops. Okay. You bought a timeshare. What do you expect? All right.
Yeah.
So otherwise, your family's going to be literally in probate trying to get this thing passed on. So now, what you may want to do, and I just seriously, this is a little conversation I had with a client on it, our timeshare, which was, they were like, man, they're like, I'd give this thing away right now. Do I really want to go to the hassle of doing this? It was only a few $100, quite honestly. They had to pay in fees to the management company and then for the deed to get done. And they're like, let's just not worry about it. I was like, okay, all right. Now, if your family uses this, it's turned into a regular vacation place. It has meaning. The timeshare in your instance is a good deal, all that stuff, then get it done. Just jump through the hoops. Timeshare is going to be a little tricky just because there's this management company involved. So I don't know if that was a catch-all for other assets because there's a lot of assets that actually pass, but there's no ownership record. There's not a deed. There's not a company certificate or an ownership thing. Like all this personal property you're going to have, like your musical instruments or the guns or certain, well, guns might be a little exception, but a lot of these things is just going to be like, here's who gets it. And you're going to put this in a memorandum of personal property that's part of this binder we talk about in the estate plan. But you're not going anywhere to have to do anything. You're just saying this is who gets it. You know what I mean?
Yeah.
And the baseball card collection or whatever,
Yeah, yeah. There's some things that there's no actual ownership on record somewhere. But
jewelry, art, like a lot of stuff has a lot of value. And it's going to, the piano, all.
I've had the weirdest things, you know what, here, I'm going to throw one out here. I have a client right now that I'm looking at today a cell tower lease agreement. So they own real property and they're going to sign a lease agreement for, I mean, it's like a 50-year contract or whatever, to lease space for a cell tower. And that contract should either be with the LLC that owns the land or your trust, if that's who owns the land. Because again, that trust is going to be the recipient of that lease payment after you die. And that could live on. And so some of you are going, oh my gosh, this is far reaching. So again, any sort of contractual income you have or asset or right to something, you want to make sure that your trust can step in and boom, grab it when you're gone.
Love it.
That was nice. That was a reach, huh? You feel that?
Yeah, I like it.
All right. I'm expecting something big from you the rest of the show. Somewhere, a little juicy nugget, as we call it.
All right.
Okay, next asset class.
All right, let's talk about where all the money is. Let's talk about your retirement accounts.
Oh my word! How did I? Jeez.
What did you expect?
Matt Sorensen.
What do you expect? I mean, it is worth, there's only $35 trillion in retirement.
Let me hold this up for YouTube. Here's Matt Sorensen's book. You can get it on Amazon right now.
Yeah.
If you call my office, I will sign it for you at my office if you would like.
Mm-hmm. Yeah, that's called
very special.
Very special.
Okay. So let's talk about retirement accounts and the $4 trillion, in retirement account, like it's a big deal.
Yeah. Well, if you've got one and you got some money in it, you probably care about who gets it, right? So I'm going to give a couple tips on it. First, you have a beneficiary designation, whether it's an IRA, 401k, HSA, covered, I don't care what type of account it is. I'm grouping all those together. You have a beneficiary designation that says upon your passing, who gets my IRA, my 401k? Now, we love having your trust involved, but if you've got a spouse, my general recommendation, and this is most advisors that are savvy on this stuff or estate and tax lawyers, we like to have your spouse first if you have one. So upon your passing, elect your spouse for your IRA, and this could be Roth, traditional, 401k, whatever, because there's special spousal rollover rules that allow your spouse to inherit your account and do it as an IRA or 401k in their name and not have to make it an inherited IRA where it has to come out over 10 years and it's more of a pain. They can just bring it into an account in their name and treat it like it's their own IRA or 401k. So list spouse first, and then trust. Your trust will be the secondary beneficiary. Now, if you don't have a spouse, you list your trust. Now, when you list your trust, and this is a directed IRA, our company, or any other, you're at Fidelity or whoever, when you list your trust, they need a copy of it. They have to have a copy of it because they have to be able to know who are the identifiable beneficiaries. Now, you can just provide a copy. You'll have a PDF copy of your trust from us that's signed that you can send. But they actually need a copy, and they don't just need the trust certificate. They need the whole thing because you need to be able to know who is the beneficiary in there when you pass. It's got to be identifiable in the document. So if it's your two kids, and that we can look in there and say, okay, this is who's going to get it. So remember retirement accounts, beneficiary designation form. You've got to update that when you sign a trust and once you have a new estate plan. Update all those on all your accounts.
Okay. Now, some people, the retort to this is, well, hold it. Mark, I'm not going to go through probate with my retirement account. Why the hell am I worried about this? And like Matt was talking about with kids, keep in mind again, your children, young or old, may not be in the right skill set, mindset, life set, situation, physically, mentally, to handle your retirement account. They could end up blowing it. And so be responsible to your children and do the right thing by maybe putting strings on it. And we talked about that back in part 2. But this is when it really happens. You've got to update your retirement account beneficiary so that it goes to the trust. If you don't say it goes to the trust, it ain't going to the trust. It's going to go to your 21-year-old at college looking for some cash to go to Tijuana this weekend. That's not where we need your retirement account.
Yeah. And let me just give an example because we've had, we have over 10,000 accounts, a lot of, we're opening a lot of new accounts. And so we see people pass away. We've had a lot of accounts, people pass away and they need to get inherited. I will tell you I can call it every time when there's someone in their 20s that inherits a retirement account, drained that next week, the whole damn thing. Okay. And that might not be what you wanted. Now, maybe you were like, you know what, if they want to, cool, but those in their 30s and 40s, they tend to keep them invested. They're like, hey, I get this. I understand the power of a retirement account. I've been working my butt off for 10, 20 years. I know the importance of having this nest egg down the road. I'm going to keep this as an inherited account and keep it growing for my future life. And so, so just think about that as you're planning. If you've got older kids, a large account, you may want to sure, I get it, have it go outright. But if you've got younger kids, even those in your 20s, the benefit of the trust here is you can have some controls in there if you want about when they get the money.
Yeah. Okay.
Now, let me say your bank accounts, you can list the trust too. And it's the same beneficiary designation thing. Your life insurance policy needs to be updated too now. List the trust as the beneficiary of your life insurance policy. The only one that retirement accounts where I say list spouse first and then trust is just because there's spousal rollover rules on retirement accounts. But for your bank accounts and your life insurance, even a personal brokerage account that's not retirement, just a brokerage trading account, that stuff, just list your trust as the new beneficiary.
And I think a lot of people just, when they start thinking about trust planning, they're like, I don't have any money. I'm not rich. I don't need a trust. And then we go, do you own life insurance? Oh, yeah. Or at work, they have a policy for me. Well, that's what we're talking about. That, again, sometimes it might surprise you how much you're really worth. And so
particularly dead.
Yeah, particularly dead.
We taking the life insurance. I'm worth $1 million.
Yeah. Touche. So I think that's a reality check for a lot of people on that note. I'm trying to think here. I've been looking through my notes. Yesterday, I did 10 mistakes we make with our retirement accounts, and this funding was such a big part of it.
Estate plan, yeah.
And so I just wonder if there's any other just kind of little things that you should be thinking about in the maintenance or funding.
Let me say a couple other ones. Sometimes we get some common questions like, what about my cars? Do I need to put my cars in this? Do I need to go to the DMV or motor vehicle or whatever? Like, not typically. You can, but generally the DMV is going to transfer with the trustee or even executor of the will which also most states say if it's a surviving spouse or kids, they show a death certificate, they can affect the transfer of title on cars. Again, that's different from real property, but typically vehicles, you don't need to stress about getting that in the trust name. In most states, those will pass based on death certificate, and trustee or surviving spouse or kids can go affect that.
Yeah. Well, I think the last thing on maintenance, it is funny. I get a lot of people that say, ooh, here's a good point. People go, well, we probably need to redo my trust. I set it up 15 years ago. And I'll say, well, hold on, slow down, Tiger. A lot of times, if you did a quality trust to begin with, a simple amendment at most to update maybe some names or this or that, maybe all you need to do. And now on that note, Matt, you had an experience this week where someone said, yeah, I need to amend my trust. And you're like, oh, okay, just send it over, a couple things. And it was the way you described it was better. I mean, you were telling some of the other attorneys this. So there's a balancing act here.
Yeah, sometimes you just need to do a new trust rather than amend a trust. It's like, okay, now I'm married. Okay, you got married now. All right. Now we might need a whole different estate plan. You might need to redo what you did. Now, sometimes we can keep the same trust name if you want. So that way all the assets you already put in the trust can stay, but we may rework the whole documents, and it's probably the same fee as a new trust. Because if you get remarried, you have a new spouse, all these assets you have, there's a lot of more caveats in it. Who gets what? My new spouse actually gets this or this percent, and then my kid this, and and by the way, this prior spouse I had in this prior plan out, like there's just a lot more going on in that. So sometimes you want to restate the whole thing and just do a new estate plan, but maybe keep the same trust name, because you already have assets in it. Now, maybe you want to change the trust name, and that's okay. You can move properties and do all this refunding again to get the right trust name on it if you have a new spouse. But just a consideration there. Some changes are significant, like remarriage, divorce, where you might start the estate plan over entirely. But other things like I just want to change the trustee, or I need to do something special for one of my kids because of whatever circumstance that might be one of my beneficiaries, that stuff you can just do through amendments.
Yeah, I love it. Good stuff. Well, everybody, this concludes. Can I say that?
Yeah, I have one important message. Important message, though.
Okay.
Okay, this is
yeah.
This is very important.
Okay.
Get your estate plan done. If you've been listening to this and you haven't started your estate plan, shame on you. Get it done, okay? You will die, okay?
Yeah.
You will. It's just a matter of when, okay? Get your estate plan done. We happen to have a special to incentivize you. $200 off. Our regular estate plan price is only $1,500. It's $1,300. We do the trust and all these other documents we've been talking about. You get to talk with an attorney to work through any questions you have. Do it in all 50 states. So get over to KKOSlawyers.com, take advantage of the special, or use someone that can help you get through this and get this done. We all need to have an estate plan in our lives. It's a way to, like we said at the beginning when we started this, to create a legacy of what you want to happen with all these assets and all this work you've put in over the years. It also avoids heartache and fighting for your family after the fact when everybody has an opinion about what you wanted to happen with your estate, but you were too lazy and didn't care enough to get it done and save your family the heartache of having to fight over everything. So,
boy, Mr. Guilt Trip, do you want to shame anyone else? This is the shaming moment of the show.
I just felt I was just moved to share that message with you all today.
Yeah, boy, yeah.
No.
Oh my gosh. Well, I was going to say this concludes our 3-part miniseries. You can catch it on American Movie Classics every Friday night after Shawshank Redemption. And we will be there for you and for many, many years to come. So this is a classic. This is going to go down in, history. This is one of the best 3-part miniseries on estate planning. Is that too much?
I mean, no. No.
You got to manifest it if you want it.
Manifest it. Oh, geez. That's so millennial of you. All right. Well, thanks everyone for listening. Of course, we'll be back next week with another amazing episode of the Main Street Business Podcast. Until then, get your estate plan done. All right.
Okay.
Thanks, everyone.
See you next week.